Hello everyone, this is me Ocean Bhatt. Today we are here to give a presentation on two cases related to contract and corporation law. First part will be done by me and Pushkar, and followed by the second part by Prajwal and Sudeep. Today we have discussed about two cases related to contract and corporation law. Uh, uh, Before going through the cases, first I want to give short description about a contract. Talking about the contract, a contract is a legal document between the two parties, which is enforceable by a law. Uh, uh, so 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 here we going to discuss about the contract law. So contract law is the document related to the contract. In part A, we have done the case study related to SOO Burger. Let me give a brief description about the case study. First, the SOO Burger announced the advertisement, and that they will present a prize to the customer if they win in a prize as a ticket, is a golden ticket. And later they did not fulfill the contract. So the parties, they have gone to the court for the case. So we have discussed about this in a part A. After this, my friend Pushkar will narrate a briefly description about this case study.
Thank you, Hasan. Hi, my name is Pushkar Kanal, and now I'm going to give the remaining of the part 1. And as my friend told the issue of the case, and now I'm going to describe the application scenario based on the issue. And the CEO Burger misprint the golden ticket, and so they cancel the promotion, and they would award only one customer. In case of Mikey, he bought a 50 burger and collected a golden ticket. Since he loved the burger and eat all the ticket, he had to rush to the hospital. And according to the Australian Consumer Law and Law of Competition and Consumer Act 2010, under Section 18, the failure to comply and promotion is labeled as deceit and fraud. However, so Burger followed the criteria but failed to go through their undertaking, so they may be liable to negligence, and so their late cancellation can be nullified, and both Mikey and Brett can be awarded. And as the prize is already awarded to Brett, the maximum penalty of 10 million can be awarded in case of Mikey. If he provide the sufficient evidence, and that is in the form of receipt, so it is wise to award him with the Mazda CX-9 as the prize. And the Mikey case is beyond the mislead and deception. Mikey suffered from exhaustion and stomach complication after eating too much burger that he loved. This may arise the misconduct and negligence. Mikey is entitled to sue with respect to loss and injury, so it is best to award Mikey the prize. As in the case of Brett, he collected the token from the throwaway bins and the friends. As per the promotion, a customer collected the token after buying. Is entitled to the prize, and since the bread did not have any receipt, so he can be entitled to nothing. And for the rest of the presentation, I like to call my friend Sudeep. Thank you.
Thank you, Pushkar. I'm Sudeep Bhatt. I'll be discussing about the part B of this presentation. Here in this sketch, which is all about the strategies and practices in the execution of managers' obligation by legal organization in Australia. So in this presentation, the company is Joytronics Private Limited, which is a retail store operator and supplier of different electronic merchandise. Here it seems lack of conformity, which results violation provision offered in section 180 subsection 2 of Corporation Act. So in this presentation, in part B, I will be talking about three issues. The first issue rely on the legal position and role of Mercedes, and the second issue is was her concurrence to purchase property protected by Corporation Act, and the third issue will be, does she breach any law of Corporation Act of their company, if it is labeled insolvent. So I'll be to discuss the first issue. Mercedes is the non-executive director. It is not compulsory that the non-executive director is hired by the company. As company operational activities was going on, the Felix dropped some ideas of relocation. Mercedes hesitantly recognized Felix's concept of relocation as a managing partner, which in turn collapsed with the threat of insolvency. Here, insolvency is the situation in which an individual or organization cannot pay off its bill and debt. So, I'll be talking about the second issue. Regarding the second issue, yes, her concurrence to purchase property was protected by Corporation Act. In this situation, she described an element of duty of performance in a good faith, good business interest, and knowledge of awareness with appropriate resolution. The element in turn promotes her contract to buy her new location and protect her in good faith, as mentioned in section 180 of the Corporation Act 2001. So in this way, I would like to talk about the third issue, and according to third issue, section 588G of the Corporation Act, it emphasizes a director's duty to prevent the insolvency of the company. Mercedes, however, hesitantly accepted the application of unqualified and unexamined decision. However, it can be seen that Felix breached the section 195 subsection 1, which expose him on the obligation of uninvolvement in conferences and violating on approval of warehouse. It may be private concern. He had on some purchasing on alternative. So in this way, I end my part, and further will be discussed by Mr. Prajwal. Thank you.
Thank you, Sudeep. Now I'm Roswell, and now I will continue my presentation after Sudeep has told all the scenario of first part of this issue. Now I'm describing the second part of this case, that is related to Mr. Greg's position and how he deals with the respect of duty of care, and further if there is any possible liability that the company will be insolvent or not. So as a result of Greg's ignorance in financial matters, and also due to his inadequate studies, but still he seems confident, and he seems always committed towards the company, so that the company will go in long run. But it is all the outcome of Felix's new prospect of running the business. It was all about the excitement of the Felix that made the new prospect. Now, if the company is deemed insolvent, all the directors will be liable in this case. But as through this idea was generated by Felix, the main priority, the main concern will be consequences will be derived from the Felix. Now, and if the Greeks and Mercedes will be protected by Cooperation Law 180 and 181. through though in defense of the company existence under 588 H of the Corporation Act 2001, it may be defended under the expected occurrence. So the company may lead ahead without recording any other past things and move ahead, and there is always saying that chances are never given, they are taken as an interception. And by telling this much, I want to wrap up my presentation on the behalf of my team members. Thank you very much.